Mr. Garcia and Ms. Klein, I see you in the courtroom, so you may proceed, Mr. Garcia, with your argument.
Yes. Good morning, Your Honors.
Morning.
Court. My name is Jamie Garcia, and I represent the appellant Rocky Valor in this matter. May I reserve 5 minutes for rebuttal?
Very good. I'll let you know when you get to that point.
Thank you, Your Honor. We are here, Your Honors, asking this court to reverse the conviction of life in prison and grant the defendant a new trial because he was deprived of a new trial due to his due process rights being violated when prosecution was permitted to make improper comments in the form of commenting on the appellant's Fifth Amendment rights, shifting the burden of proof, making personal attacks on defense counsel, and the appellant not being granted a severance of the charges on March 3rd, 2018 from the charges on March 7th, 2018. In this 3-day trial, evidence was presented and witnesses were presented by both sides. There were 2 charges on March 3rd, 2018, one being an armed robbery with a firearm and the second of a grand theft. On March 7th, 2018, there were charges of aggravated assault on a law enforcement officer, resisting arrest without violence, and driving while license suspended. All the evidence and all the testimony on the March 7th, 2018 charges was corroborating the same. It was the appellant was the driver of the stolen vehicle. His brother was in the passenger seat. They were arrested, and neither of them made a statement to law enforcement at the time of the arrest. On March 3rd, 2018, those charges is where the witnesses had contradictory statements between the state's witnesses and defense witnesses. On the March 3rd, 2018 armed robbery with a firearm and the grand theft, the defendant presented 3 witnesses: his brother, his fiance, and a girlfriend. All of those witnesses testified that the stolen vehicle was first given to the brother, and the 2 ladies who testified on behalf of the defendant testified to the whereabouts of where the appellant was, and hence showing that he could not have been the person that pulled out a firearm and robbed those 2 individuals for their keys, which resulted into the grand theft. It is our position in closing and rebuttal closing, when the prosecution was permitted to make the following statements where the due process rights of the appellant were violated. First, the prosecution stated in closing with the phrase of, "Do you think that this defendant does that if he has no idea that this car is stolen, how it got stolen? His brother wanted to tell you, oh, we didn't know what was going on. So why do you drive at a cop? It doesn't make sense." The prosecution goes on to say, "Did you tell the cops that on March 7th? At that point, an objection was made, which was overruled. The prosecution went on to say in closing, "What did you tell him then?" "Nothing." "Why does he tell him nothing on March 7th? They're both in custody. Wouldn't it be reasonable at that point that this is actually going to happen? Wouldn't you want to try to come in and tell them here today where you got the car? Wouldn't that be helpful information at the time of the arrest for law enforcement's investigation?"
But weren't those statements directed toward Caleb as opposed to Rocky?
It is our position that they were not. But even if they were obscurely under the fairly susceptible test, which is a liberally applied test, it is whether the jury would have had a chance of confusing them. And why it's our position that they were not at Caleb and more at Rocky is because, one, there was never a question of who the driver was. Mr. Valor, the appellant, was found behind the wheel of the stolen vehicle. And when the prosecution specifies driver and then goes singular pronoun of he wants you now to know this, and why didn't you tell the cops on that? At the very least, it is our position of the fairly susceptible test that the jury would confuse as far as the driver, the singular pronoun of you, and he going to the comments of the Fifth Amendment rights of Mr. Valor.
But the only person who was telling the jury anything now was Caleb, because he's the only one who testified at trial, not the defendant.
It's correct. The defendant did not testify at trial. The prosecution doubled down by using then a pronoun that was both, as far as a compound pronoun, by using the words they were arrested, they were in custody. And under...
But Mr. Garcia, to follow up on Judge Rossin-Yoakum's question, the discussion seems to be, he is telling you, Caleb is telling you today this story. Caleb had the opportunity but did not tell that story before. I'm not certain how that can be fairly susceptible as a comment on the defendant's right to remain silent.
It's our position that it is when the prosecution uses the pronouns they were in custody as far as putting a comment to the Fifth Amendment right at the time of arrest when both Caleb and the brother were in custody. And under the Hogan's decision, the Florida Supreme Court has determined that there cannot be any comments made at the time of arrest of the Fifth Amendment. In fact, under the Harwitz, Florida has even extended it to pre-arrest. So by the use of the pronouns, they were in custody at the time, and why didn't they tell law enforcement at that time? It is our position to comment both of Caleb's, the brother's Fifth Amendment rights, as well as Rocky Valor's Fifth Amendment rights at that time. Also, they talk about, as far as the pronoun we, they said we were at the time being arrested. So by the use of those two pronouns of they and we, it is our position that there were improper comments made at the Fifth Amendment rights of Mr. Valor. Both were objected to, both were overruled. And in fact, I was the trial attorney. I even asked to approach, Your Honor, to specify this and was denied that right. Also, it is our position that as well as the comments by the prosecution of what I failed to explain to this jury is how all these things happen, go to an improper shifting of the burden. It is our position that when the prosecution stated that I had no explanation for how these events occurred, it shifted the burden, and is very similar to the case we cited in Gleason v. State. In Gleason v. State, the prosecution made the comment that there was no explanation as to why the defendant in Gleason had the stolen property. That conviction was overturned because of that comment. It is our position that our case is even more egregious because in this case, the prosecution commented on his experience of what all defense counsels do. He then went further on to say what Mr. Garcia fails to do here is to explain how all these things happened to this one person. That is, in our position, is a shifting of the burden.
Why isn't that just a comment that the defense failed to rebut the state's evidence establishing guilt? In Gleason, the argument was basically, well, unless there's an explanation for this, for what happened, you have to find him guilty, which suggested that the defendant had to come forward with an explanation for what happened. Here, the state has presented its evidence concerning what happened. And why isn't the prosecutor's argument simply the defense has failed to rebut the evidence that we have presented? Why isn't that a fair interpretation of the prosecutor's argument?
It is our position that it's not a fair interpreted because of the words fail to argue and explain to you how all of these things happened. By putting the word all of these things happened, it is making an improper shift of burden is our position that the defense has to explain how all of these events and all of these matters happened, not just to the guilt of the certain crimes. By putting that burden on the defense and specifying it directly at defense counsel, it is our position that the prosecution was using defense counsel as a tool against his own client by stating that I failed to explain and argue all of these matters that occurred for this individual. Based on that, it is our position that under the harmless error test, because those were objected to at the time and overruled, that the state cannot meet their burden of proving beyond a reasonable doubt these comments did not contribute to the guilty verdict. Moving on to the third improper comment deals with the personal comments of defense counsel. In the rebuttal closing, the prosecution was permitted to ask or to argue to the jury and state that they had a chance to see the defense witnesses. We will concede that prosecution can comment on witnesses and their testimony. But what the prosecution did here is go further by saying, you don't think they, meaning the witnesses and defense counsel, knew what he, defense counsel, was going to ask them. You don't think that that's something he had met with him about and covered in detail, maybe even given them a list of questions. I don't know. They didn't come here blind what was going to be asked to them. And the reason why that language is important is because in the beginning, the prosecution talks about them getting to tell the truth of their story, the truth of the story. And how that's improper at the time is because under Lewis v. State, it is our position that those comments go to talk about me possibly coaching, influencing, or somehow constructing perjured testimony by these witnesses.
But the prosecutor didn't use the word coaching, correct? That prosecutor didn't say that. Also, wasn't it reasonable for the prosecutor to highlight the difference between the defendant's or the witness's testimony on direct exam and cross exam? I mean, it was remarkable. You know, on direct exam, you've got McCants remembering 3 years later the type of pizza they ordered. But then when asked if she was working at the time, she couldn't even, she suddenly fell apart and couldn't even remember whether she had a job at the point. So wasn't that fair of the prosecutor to highlight the distinction between, well, when the defense is asking the questions on direct, they know all the answers. On cross, they don't know all the answers. Coupled with the trial court's instruction to the jury that it's perfectly proper for witnesses to meet with counsel. And there's no adverse inference that can be drawn from that. Taking those things together, in addition to the fact that there was no objection made, I don't think, to that particular argument, why do we have reversible error based on that?
Yes, Your Honor. And there was no objection made. We can see that point. And yes, if the prosecution had just stopped there as far as the distinction between the witnesses, their specific recollection of direct compared to cross, then we would not have much of an argument here today. But it's the point of going past that by, at the very least, insinuating by stating that defense counsel had met with these witnesses, had gone over in great detail.
Which the trial court said is absolutely appropriate.
Correct. Giving them a list of questions and then saying, I don't know, when there was no evidence of that whatsoever during the trial, as well as me meeting with them. At the very least, it's an insinuation that I somehow constructed or directed some of this, what is perceived as perjured testimony. And using the language of the same comment in Lewis v. State, the 4th DCA overturned that conviction of a felony murder when the prosecution argued the comment of what you saw was an extremely well-produced and directed and scripted story. And as sure as I'm standing before you right now, you know that they went over and over and over that story until they got it right. It is our position that our case is even more egregious because in Lewis, the comment is made that there was a lot of practice going over and over for that story, where in our case, the prosecution is stating that the questions and the detail that were given to these witnesses were orchestrated by defense counsel. That argument, just like the court said in Lewis, gives at the very least an impression to the jury that defense counsel must believe that the defendant is so guilty, he has to resort to these impractical as well as unethical and inappropriate tactics to try to prevail in this case. Because of that reason, as far as the language in Lewis and in Thornton v. State, where the 3rd DCA reversed a first-degree murder when the comment was at closing, that defense counsel says that physical evidence can't lie, but witnesses, you can get them to say what you want. Is that what happened with Karen and Spider? They were going to say what the defense wanted them to. 2 years later, that defendant was hung. That comment resulted in a reversal. It is our
Mr. Garcia, you've used 15 minutes of your time. If you wish to reserve the rest for rebuttal, or you can go forward as you see fit.
Okay, I'll wrap it up in the next 30 seconds. Thank you, Your Honor, for that. It is our position that that is why the comments in our case were more egregious than in Thornton and in Lewis. Thank you all for your time.
Very good, Mr. Garcia, and you'll have the 5 minutes. And just a reminder, we are fully familiar with the briefs, so we will, even though you might not have gotten to all your points, we will have those for consideration as well.
Thank you, Your Honor.
You're welcome. Ms. Klein?
Good morning. May it please the court. Catherine Klein, the Attorney General's office in Tampa for the state. I guess we're talking about the prosecutor comments and the allegations that there was improper comments in this case. First, I'll address the comments that were discussed regarding the prosecutor's statements about Caleb Velour and what he testified to at trial. These statements about Caleb not coming forward and saying that this mysterious and recently deceased Robert Brewer had actually given him the car were comments about Caleb's credibility. And there's not any comment about Rocky Velour's right to remain silent. These are not in the context of the closing argument and the case. Caleb Velour was had just testified. These comments were not fairly acceptable as being a comment on Rocky Velour's right to remain silent. As far as the comments that the counsel claimed shifted the burden, again, these were comments on the credibility of the defense witnesses. They were proper comments that the defendant had failed to rebut evidence establishing guilt, and he had not established reasonable doubt.
Ms. Klein, I don't know that Mr. Garcia addressed this comment, but it was briefed, and so I'd like your thoughts on it. It's in the rebuttal closing where I don't think there's any confusion about who the state was referring to in this comment. What did you tell him then? Nothing. Why does he tell him nothing on March 7th when he knows that his brother is already in custody? They both are. Would it not be reasonable at that point that if this is actually what happened, wouldn't you want to try to come in here and say today, oh, we got a car from this other guy, this guy, Robert Brewer? I mean, don't you think that would be information that would be helpful to law enforcement's investigation? I mean, that to me, that seems a little bit clearer that we're referring to Rocky and not Caleb.
It's the state's position that they are still referring to Caleb. Caleb is the one who came in and testified that this car had been given to them by this man, Robert Brewer. And he had just testified to this. And I think that argument is still a fair comment on the credibility of Caleb and not a comment on.
But when we're told repeatedly by a court higher than ours that the standard is both liberal and fairly susceptible, and that these are high risk errors, you know, that's the kind of framework we have been given to work with. Would you concede that this one's on the line?
I would say, if you take in the context of the entire case, that the jury would know he was commenting on.
Oh, he doesn't say Caleb or Rocky. How are they supposed to know? I mean, he's freely meandering in his pronouns.
The jury knows who's there and who just testified, and it is
right. But at this point, we're in rebuttal closing. I mean, they've now been sitting through what, an hour of lawyers' arguments.
I don't know. The entire. They certainly, that is the last. I think that was the last witness they heard.
I mean, your argument is basically Caleb was the last guy they heard from, so clearly that must have been what the prosecutor was referring to when we get to closing rebuttal.
My argument is not that.
Okay.
My argument is that the comment was on Caleb Balleur and his credibility, and why, 3 years later we have this story that someone who's now conveniently dead took the car. And why wouldn't somebody have come? Why wouldn't Caleb have come forward? Caleb was not arrested.
What you just said is, why wouldn't somebody come? I mean, isn't that the problem? Is that somebody could be referring to, why isn't the defendant telling you the story? I mean, I mean, you said it. I'm sure it was inadvertent the way you said it, but that's what happened.
Yes, I say I misspoke.
And that's what happened at trial as well. Is you do
I
have.
think the jury would understand the saying that you understood that I misspoke.
You hope they do, but when you just said, but what you said, that certainly seems to be an implication that the defendant could have come forward with the story as well.
Well, again, the state's position is still going to be that this was not a comment on his right to.
And Ms. Klein, that's fine. I understand the state's position is this is not what we're reading, but the words are here, and what your argument needs to be, at least under the framework that we've been given by DeGilio and other case law, your argument needs to be, well, that's not what they said. It also needs, your argument needs to be, and that could not possibly be, it could not fairly be read as that. And I haven't heard you make that argument. I've heard you make the argument, I don't read it that way. That's the state's position, but I've not heard you make the argument, hey, Judge, you're fly specking here. This could not be understood that way. Can you make that argument that this could not be understood to refer to Rocky Balleur?
Well, certainly the state's position is, if one could understand that, it certainly is harmless. But I'm not saying that wasn't a comment on Caleb Balleur's right, Rocky Balleur's right to remain silent. I mean, this is an unusual situation where we have brothers in the same vehicle both getting arrested. Caleb was ultimately not charged in this offense.
Wasn't the context surrounding that entire unfortunate use of words the context of what occurred on March 7th when they were arrested?
They're talking about
when he said, would it not be reasonable at that point that if this is actually what happened, wouldn't you try to come in here and say today, oh, we got a car from this other guy, etc.? I mean, don't you think that would be information that would be helpful to law enforcement's investigation? So even though the word today was used, the context was of what occurred on March 7th during the course of the law enforcement investigation?
Yes, I would say that is a correct assessment of what was going on in the argument. That if they knew at that time, if Caleb knew at that time that they just got this car, or he just got that car from Robert Brewer, why would Caleb wait so long when his brothers arrested him and in jail for years on this crime?
So by today, it meant that day.
That day.
It was certainly an artful choice of words, but in the context, it was clear that was what the meaning was.
And yes, and I think you have to consider these arguments, as a whole, including, and the trial, the context of the trial, the witnesses who have been heard, the preceding arguments. This is all in context, and the jury, I don't think these comments were reasonably susceptible to being a comment on Rocky Balleur's right to remain silent. If you'd like to move on to the third category of comments, these are comments that allegedly personally attacked defense counsel. First of all, these comments aren't preserved, and you have to consider them under the fundamental error standard. And this has to be the type of error which reaches down to the validity of the trial itself, to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. And these comments, the prosecutor didn't say that defense counsel told the witnesses what to say. He didn't say that they were coached. It's perfectly proper for attorneys, as the jury is instructed, to talk to their witnesses before they testify. And these witnesses were significantly impeached regarding their memory and their amazing ability to remember a specific date, but not to remember much else. And these comments were fair comments on the credibility of the witnesses. And at least one of the cases that defense counsel cited, Lewis, is distinguishable. At least, first of all, the comments were more egregious, and it was preserved in that case by objection, contemporaneous objection. So, and I believe the other case he mentioned is also similarly distinguishable. So the state would conclude, if you have no further questions.
Before you do conclude, I want to talk about the severance issue. You argued in the brief that the crime of grand theft of the Camaro was still ongoing when the Camaro was stopped 4 days after the armed robbery and the grand theft. Is there any case that supports the proposition that the act of grand theft can take place for days beyond when the property was stolen?
I don't think I can cite a case for you at this moment, but at the time the car was.
Well, you cited the case of Rutherford. You cited the case of Rutherford, where it talks about a period of time of 12 hours, and the police confronted the defendant 2 blocks from where the crime occurred, still wearing the same clothes and so forth. So I don't see anything in your brief that supports the argument that the crime of grand theft can be ongoing for a period of 4 days after the property has been taken, removed from the location, and they find the defendant some distance away from the scene of the crime.
Well, the defendant is still in possession of the stolen vehicle at the time.
If they spotted him a year later driving the car, the crime of grand theft is still ongoing?
It takes a while to apprehend him, but he's still depriving the owner of that car of the use of that car, which is part of, a theft of, either permanently or temporarily depriving someone of the car.
Any case over any period of time in which property is stolen, there would never be a proper basis to sever the charges of the grand theft from whatever other charges might arise, as long as the stolen property is still in the possession of the defendant.
I don't think I said that in my brief. And then I
also argued. Wait. If the crime is ongoing, then it seems to me your position has to be that there can be no severance because the first crime is still ongoing.
Well, in this case, there was the crime that the vehicle was stolen. There was the robbery, it was stolen. It was only 4 days between the theft and the car being noticed by law enforcement and being stopped. It would argue that this is, close enough in time. I wouldn't say that.
So help us out, because this can leach over into other issues. I mean, by the lights of your argument, there may be an issue about when statute of limitations would start to run on this. I mean, if it's ongoing, as long as you're holding on to that property, I guess you're good to go. I mean, there's no limit. So you said it's not that long. All right, pick a day, pick an amount of time. How do we know when it's been a sufficient length of time between the two, such that we would say, this really we ought to tell a trial court, you really ought to sever this?
Well, I don't think that severance would rely on that alone.
But that's the light of your argument, though. Your argument here is strictly temporal. Look, 4 days. 4 days is a long time. That's enough to say that they're separate. It's a separate criminal episode. I'm following that path that you've laid for us, and I'm wondering, okay, temporality is the only vector, it's the only measure, fine. What is the amount of time that becomes a cutoff?
Well, I don't think I argued that temporality was the only factor. I think the state's argument is that these crimes also were causally connected. We have a robbery of 2 individuals of their keys to this car. The car is taken, a bolo goes out. The car is stopped 4 days later. These crimes are sufficiently connected, and the trial court did not abuse its discretion in denying the motion to sever in this case.
Okay.
Let me ask you a related question. You've argued, I believe, cases where the presumption comes up from recently stolen property as far as establishing entry into a building with the intent to commit a crime. And those cases talk about what is recent, you know, how far is it? Those cases don't talk in terms of, well, if you've got property at any time, that crime is ongoing, so therefore it doesn't matter what the timing is. And yet the cases do draw a distinction as far as what is recent. So is that analogous to how we should view this case, the severance issue in this case?
I think certainly that line of law could be analogous. The recent possession of recently stolen property does give a presumption of guilt, and in this case, we also have the causal, as I'm saying, the causal connection between the two crimes, not just relying on the fact that this was as I said in my brief, ongoing. So you have both things here, and these crimes are sufficiently connected.
It's interesting to me. The trial court seemed to focus as a critical component the fact that the keys were stolen, the keys were in the car, they were in the ignition, and you have the defendant driving the car with the keys present. So it seems to me, while the court does talk about the 4 days, isn't it heavily focusing on the existence of the stolen keys in the car at the time of the stop?
And that would be significant because those, it's not just it's not just the car that he took, the stolen property. They did include the keys and the wallet. The wallet, I don't believe, was recovered. But so they have the defendant's keys that were taken directly from him in the vehicle. The victim's keys in the vehicle with the car, with the defendant, Rocky Velour, driving the car, and then trying to lunge the car at an officer, showing a consciousness of guilt as well.
Let me ask one other question on this issue. You conclude your argument by saying, even if the crimes were tried separately, because they were connected and intertwined, the evidence of the other crimes would have been properly introduced. Are you saying there was no way they could try the other charges without having to have the other information come in?
I think to make the case.
You didn't cite anything. You didn't cite anything or present any argument other than a conclusory statement that the crimes were interconnected or intertwined, and the evidence of the other crimes would have properly been introduced.
But I think certainly say like when they stop the theft, they have the car. The car gets stopped, so you have to introduce the fact that we recovered the car and the defendant was in it, and you could then introduce like his actions that demonstrated consciousness of guilt by lunging the car at the police officer. I suppose that driving while license suspended could potentially have been severed, but then as the trial court commented, that might have provided, they might not have wanted to sever that because that might have provided him with some other motive other than consciousness of guilt for the robbery, for lunging at the police officer, assaulting the police officer. If this court has no further questions, would ask that this court affirm the appellant's convictions and sentences. Thank you.
Thank you. Mr. Garcia, you have your 5 minutes of rebuttal.
May it please the court. Your Honors, it is the appellant's position that these charges from March 3rd and March 7th should have been severed. The appellant's position is that theft is complete upon the taking of the property. More importantly, as the courts have ruled prior, severance is granted liberally when there is prejudice likely to flow from one set of facts to the other. Does not
I do want to ask one question. The state did not argue this, but would the fact of the car being stolen, which apparently was the reason for the stop, would that have come in if there was a severance of the other charges?
It is the appellant's position that that could come in. Where our argument deals mainly with the severance is more as far as the charge of the armed robbery with a firearm. The potential of prejudice from a crime of that magnitude is similar to the Williams v. State case that we stated. The state could have presented the possession of the stolen vehicle, the grand theft, in the case of the March 7th facts of the aggravated assault on law enforcement officer with a deadly weapon of that vehicle. It is the facts of the possession of a firearm during a robbery, that charge. There is where you have the probability of the potential prejudice as a result of a crime of that magnitude. And what the Fourth District Court of Appeals in Williams v. State said is in that case, when there was a firearm stolen from a law enforcement officer's vehicle on one day, and then several days later, that firearm is used in a manslaughter charge, that court reversed on the trial court's denial of a severance because of the potential prejudice of the magnitude of that charge of a theft of a firearm of a law enforcement officer flowing into potential prejudice into the jury determining fairly and impartially each individual charge. It is the appellant's position that the armed robbery of the firearm will flow into and cause prejudice to a jury who then has to determine whether this officer was assaulted with a dangerous instrumentality in the vehicle. It is the appellant's position that the severance should have been granted for him to have a fair determination of guilt or innocence with each charge. Under the severance factors, which as far as the court can consider as far as geographical, as far as temporal and the nature of the crimes, you have crimes that are committed on March 3rd in Bradenton, Manatee County, and then on March 7th, 4 days later, in Oneiko, Manatee County, which is outside of the city of Bradenton. You also have no causal connection between the armed robbery with a firearm as to the arrest on March 7th. And as a result of that evidence coming in, it is the appellant's position that that potential for the prejudice of that evidence contaminated the jury's findings. In closing, with regards to issue 1, we submitted yesterday a case of Kirk v. State as far as the Fourth District Court of Appeals, 1969. And I've never been a prosecutor like other people have, but in that case, the court reminded us that the prosecuting attorney during trial in a criminal case has an even greater responsibility than counsel for an individual client. And it's for the purpose of the individual case that that prosecutor represents the great authority of the state of Florida. And that court stated that it is the duty of the prosecutor to not obtain convictions, but to seek justice, and he must exercise that responsibility with circumspection and dignity to the occasion calls. Because that court stressed, when you're a prosecutor, cases brought on behalf in the state of Florida should be conducted with a dignity worthy of the client. For those reasons, and the reasons mentioned in our brief, the appellant requests that this court reverse the trial court's conviction and grant him a new trial. Thank you all for your time.
Very good. Thank you both. You will be asked to leave the courtroom. Again, you may stay and watch the stream if you wish, but we will now proceed to the next case, Stein versus Marx.
Thank you all.
Thank you.